Welcome to this deep dive. Today we're tackling a topic that, well, eventually touches every single life. What happens to your stuff, your responsibilities after you pass away?
Yeah, it's a big one.
Think of this as your look inside the world of South African succession law. We've gone through some really interesting sources, legal lectures, an exam guide.
A mix of the academic and the practical, really.
Exactly. And our mission today, to give you a clear picture of who gets what, how it all works here in South Africa, whether there's a will involved or, well, not.
We want to sort of demystify it a bit, give you the core knowledge without drowning you in legal jargon. So if you've ever wondered about the what-ifs for your own situation, you're definitely in the right place.
Okay, let's dive straight in them. First up, intestate succession.
Right?
This is the legal setup that applies when someone dies without a valid will, right? Or maybe the will they had doesn't cover everything.
Or it becomes invalid for some reason, yes. Essentially, intestate succession is the law stepping in saying, okay, you didn't leave instructions, so here's the default plan.
A kind of safety net.
You could say that. It provides a structure, ensures things are distributed in an orderly way when there are no specific wishes documented in a will.
And who actually inherits in this situation? Is it just close family?
Generally, it's natural persons, yes. But what's really key here, and something that's evolved a lot, is how inclusive South African law has become.
How so?
Well, for instance, a child's right to inherit isn't tied to their parents' marital status anymore. So children born outside of marriage, even from adulterine or incestuous relationships, have the exact same inheritance rights.
That's a major shift from older views.
Absolutely. And the law keeps up with modern families, too. It explicitly recognizes kids born via artificial fertilization, surrogacy. Adopted children are treated exactly as biological children of their adoptive parents for inheritance. It's all about equality.
That's really significant. What about a child conceived but not born yet when the parent dies?
That's covered by something called the nasciturus fiction.
Sounds intriguing.
It basically means the law pretends the conceived child was already born, if they're eventually born alive, so that unborn child can inherit. It protects their potential interest.
Okay, I see. Now, you mentioned things evolving. I understand there was a very different system under customary law historically. Something about the eldest son.
Yes, that's right. Historically, male primogeniture was the norm in many customary law systems. The eldest son inherited pretty much everything.
Which obviously wasn't very fair to daughters or younger sons.
Not at all. And the Constitutional Court agreed. Landmark cases like Tribe v. Magistrate, Kalitcha, and others challenged this directly.
What did the court decide?
They found male primogeniture unconstitutional discriminatory. It violated the rights to equality and dignity. This was a huge step.
So what's the situation now for customary law estates?
Following those court cases, legislation was passed. The Intestate Succession Act, which used to apply mainly to civil marriages, was extended to cover customary law estates too. And then the Reform of Customary Law Succession Act specifically abolished male primogeniture. Meaning now, for deaths after these changes, the same principles of equal inheritance apply, whether it's under common law or customary law. It's much more unified and fair.
That's a really positive development. Okay, so let's get practical. If someone dies intestate, what's the actual order of who inherits? Can we break that down?
Sure, the Intestate Succession Act sets out a clear hierarchy.
Rule number one.
If the deceased leaves only a spouse or spouses and no children or descendants, the spouse or spouses get the entire estate. Simple as that.
Okay. What if there are children but no spouse?
Then the descendants' children, grandchildren, inherit everything. And it works through representation. So if a child died before the parent, that child's own children, the grandkids, can inherit their parents' share.
All right, representation. Got it. Now, the common scenario, spouse and kids.
This is where it gets slightly more complex, but there's a clear rule. The surviving spouse or spouses inherit either what's called a child share or a set amount, currently are $250,000, whichever amount is greater.
Whichever's more money for the spouse.
Exactly. The descendants then inherit whatever's left over.
Can you explain that child's share a bit? How's that calculated?
Okay, imagine an estate is worth, say, our $600,000. There's one spouse and two children. You count the spouse plus the children, that's three people.
Okay.
So you divide the estate value, our $600K, by 3. A child share would be our $200,000.
Right.
Now the spouse gets the greater of that child share, our $200K, or the fixed amount, our $250K. In this case, our $250,000 is greater.
So the spouse gets our $250K.
Correct. And the remaining our $350,000 our 600K minus our 250K, is then divided equally between the two children.
Ah, okay, that example makes it much clearer. What if there's no spouse, no kids? Where does the estate go then?
The law looks upwards and outwards. If both parents are alive, they inherit equally half each.
And if only one parent is alive?
If one parent is alive and the deceased parent has left descendants, so the deceased siblings or their kids, the surviving parent gets half and the descendants of the deceased parent get the other half.
Divided amongst the siblings, except
Or their children through representation, yes.
And if no parents are alive, but there are siblings or niece-nephews,
Then it gets split. The estate is divided into two halves, one for the mother's side, one for the father's side. The descendants on each side inherit that half.
interesting split. What if there are only relatives on one side, say, only maternal cousins?
Then those descendants from that one side inherit the whole lot.
And if it goes beyond that? Really distant relatives?
The law says the nearest blood relation inherits.
Yeah.
It keeps looking until it finds someone.
Wow, okay, it really does try to find an heir. Now, you've mentioned spouse a lot. Who counts as a spouse under this law? Has that definition changed?
It definitely has. It's much broader now, reflecting, modern South Africa. Crucially, it now includes partners in permanent life partnerships where there was a reciprocal duty of support.
So, not formally married, but in a committed, supportive relationship.
Exactly. That came from amendments and landmark cases like Bwanya v. Master.
Yeah.
Also definitely includes spouses from customary marriages and Muslim marriages, thanks to cases like Daniels v. Campbell.
So the definition is quite inclusive now.
Very much so. It aims to protect people in various forms of committed relationships.
That's a really vital update for people to know. Okay, let's switch gears. We've covered the no-will scenario. What about when someone has taken that step and made a valid will? That's testate succession, yes.
Precisely. Testate succession is where the distribution follows the instructions left in a valid will. It's grounded in the principle of testamentary freedom, your right to decide who gets your assets.
Makes sense. So what does it take for a will to actually be valid in South Africa? What are the absolute must-haves?
There are a few core things. First, the person making it, the testator, must have had the intention to make a will animus testandi.
They meant for this document to be their will.
Yes. And second, they must have done it freely, volition, no undue influence, no being forced into it.
Okay, intention and free choice. What about the person themselves? Can anyone make a will?
The Wills Act says anyone age 16 or over can, provided they are mentally capable of understanding what they're doing, the nature and effect of making a will.
And if someone disputes that capacity?
The burden of proof is on the person challenging the will to show the testator lacked capacity. The law presumes capacity otherwise.
Right. And the witnesses? Who can witness the signing?
They need to be 14 or older and competent to give evidence in court. Basically, credible individuals.
Okay, testator requirements, witness requirements. Now, the document itself, are there strict rules about signing it?
Very strict, actually. These are the formalities, designed to prevent fraud. The will must be signed at the very end by the testator.
Or someone signing for them?
Yes, a proxy can sign on the testator's direction. And then every other page also needs to be signed, anywhere on the page, by the testator or proxy.
Every single page?
Every single page except the last one, which has the main signature at the end. And crucially, all this signing has to happen in the presence of two or more competent witnesses.
Both present at the same time?
Yes, present together. And then the witnesses must also sign the will in the presence of the testator and each other.
It sounds like a very specific ceremony.
It is. And there's one more layer. If the testator signs with a mark, like an X, or if a proxy signs, a commissioner of oaths must also be there to certify everything.
Wow, that's a lot of hoops to jump through. What if someone messes up one of these steps? Is the will just automatically invalid?
Not necessarily, thankfully. There's a provision, Section 2.3 of the Wills Act, called the power of condonation.
Condonation.
Yes. The High Court can overlook certain formal defects. If the court is satisfied that the document genuinely reflects the deceased's final intentions, it can declare it a valid will despite the error in execution.
So the court can save a will that has a technical flaw?
It can, yes.
Yeah.
It focuses on the testator's intent. This power can even apply to copies of lost or destroyed wills, though there's a hurdle there, a presumption the testator destroyed it intending to revoke it.
That needs to be overcome.
Right. But it shows the law tries to uphold genuine wishes over strict technicalities sometimes.
That seems fair. Now, thinking about who can inherit under a will, can you leave your assets to anyone or anything?
Pretty much, yes. Generally, adults, minors, even an unborn child, that nasciturus principle again, Illegitimate children, absolutely. Someone of unsound mind can inherit, though a curator would manage it. Even someone who is insolvent can technically inherit.
Although their trustee would likely step in.
Exactly, for the benefit of creditors. And importantly, you can leave assets to juristic persons, companies, charities, organizations.
Okay. But are there people who are specifically disqualified from inheriting, even if they're named in the will?
Yes, there are some key disqualifications. The big one is the bloody hand, rule de bloedige hand.
Sounds dramatic.
It means someone who unlawfully caused the death of the testator cannot inherit from them. You can't benefit from your crime. And this isn't just murder. It can extend to other really despicable conduct towards the deceased.
Okay, that makes moral sense. Any others?
Yes, people involved in the execution process are generally disqualified. This includes the witnesses, anyone who signed as a proxy, or anyone who wrote out the will in their own handwriting for the testator.
And their spouses, too.
And their spouses, yes. It's to avoid any hint of undue influence or self-interest in the will-making process.
Is there any exception there?
There is one. They can still inherit an amount up to what they would have received if the person had died intestate without a will. So they don't get more than their intestate share just because they were involved in making the will.
A sort of compromise. Prevents them being totally cut out if they were a natural heir, but stops them gaining extra benefit.
Precisely.
Now, I came across a term, pactum successorium. What on earth is that?
Yes, it sounds complex.
Yes.
It's basically an agreement, a contract made during someone's lifetime where they try to regulate how their estate will be distributed after death.
Like a pre-inheritance agreement.
Sort of. But the key thing is, these are generally held to be invalid in South African law.
Why?
Because they clash with testamentary freedom. You have the right to change your will anytime before you die. A contract trying to lock you into distributing your assets in a certain way infringes on that freedom. The proper way to direct your inheritance is through a valid will, not a side contract.
Okay, so the will is supreme. You can't really contract your inheritance away while you're alive.
That's the general principle, yes.
All right. So whether there's a will or not, someone passes away. What actually happens next? How is the estate dealt with? This is the administration process.
Exactly. The administration of deceased estates. It's the whole process of gathering assets, paying debts, and distributing what's left to the heirs. And it happens whether it's intestate or testate, always under the supervision of the master of the High Court.
Who kicks things off? Who has to report the death?
The estate has to be reported to the master within 14 days of death.
Yeah.
Usually it's the surviving spouse or the nearest relative or connection living in the area where the death occurred.
And it's important to do this correctly.
Very. Tampering with a will or giving a false inventory of assets is actually a criminal offense. Honesty is crucial from the start.
Makes sense. I understand the process differs depending on how much the estate is worth.
That's right. There's a distinction based on value. For small estates, currently those valued at R$250,000 or less, the masters can streamline things.
How so?
They might not need to formally appoint an executor. They can just give directions for how to wind up the estate and appoint a master's representative with what's called letters of authority. It's often simpler, potentially faster, and might not need an attorney for the paperwork.
And for larger estates over that R$250,000 mark?
That's the more formal route. An executor must be appointed and they receive letters of executorship. The whole process follows detailed steps laid out in the Administration of Estates Act.
What kind of steps?
Things like opening a specific estate bank account, formally advertising for creditors to come forward with any claims against the estate, evaluating those claims, paying debts. It's quite involved.
And this usually requires professional help.
For estates over R$250,000, yes, almost always. The complexity means you generally need an attorney, notary, or conveyancer to handle the administration and especially to prepare the main financial document.
Which is the L&D account.
The liquidation and distribution account, yes.
Yeah.
That's the core document detailing everything.
So what is the main job description for this executor or master's representative?
Their core duty is to step into the shoes of the deceased, financially speaking, collect all assets, pay all legitimate debts and administration costs, and then transfer the remaining balance, the residue, to the correct beneficiaries, according to the will or intestate rules.
And that L&D account captures all of this. What's actually in it?
It's very comprehensive. It starts with a heading deceased's details, master's reference number. Then you have the liquidation account section listing all assets and liabilities.
Does that include things like life insurance?
Usually not, if there's a nominated beneficiary on the policy. That typically pays out directly to them outside the estate.
Okay. What else is in the L&D?
There's a cash recapitulation statement, basically showing the estate's cash flow. Then the critical distribution account, showing exactly who gets what from the residue. There's also an income and expenditure account for money earned or spent after death, including the executor's fee.
Right, the executor gets paid.
Yes, typically 3.5% of the gross asset value plus VAT. That fee is listed there. You might also see a fiduciary assets account if the deceased managed trusts, and an estate duty addendum to calculate any potential estate tax.
And finally,
A certificate signed by the executor, declaring everything is true and correct to the best of their knowledge.
it really does sound like a full accounting. What if the executor gets it wrong? Makes a mistake in who gets paid?
They're personally liable. Section 50 of the Act is very clear. If an executor distributes incorrectly, they can be forced to pay the shortfall themselves or recover wrongly paid assets. That's a serious responsibility.
Emphasizes the need for care or getting professional help.
Definitely.
And can an executor be fired, so to speak, if they aren't doing their job properly?
Yes. Section 54 allows the master or the high court to remove an executor for misconduct, incompetence, conflict of interest, or other good reasons. There are checks and balances.
One last practical point, I saw a note about law clinics. They generally don't handle winding up estates.
That's correct, based on the Legal Practice Council rules. Rule 36 generally prohibits law clinics from taking on the administration of deceased estates or related property transfers.
Why is that?
It's likely due to the complexity, the time involved, and the significant potential financial liability we just discussed. Estate administration often requires quite specialized expertise that clinics might not be set up for.
Okay, got it. So let's try and pull this all together. When someone passes in South Africa, their estate goes through a defined legal process in testate succession if no valid will, testate succession if there is one.
Right. Both have clear rules shaped by laws and court decisions aimed at fairness, including protecting previously marginalized groups.
And the whole administration process, whether simple or complex, is overseen by the master of the High Court, with specific duties for the executor or representative.
Exactly. It's a structured system. Hopefully, after this discussion, you have a much clearer handle on these core principles.
Absolutely. This has been incredibly enlightening. It really highlights how the law tries to balance respecting someone's final wishes with ensuring fairness and order.
It does. And reflecting on all this, perhaps it brings up a final thought for you, our listeners, to ponder.
Go on.
Considering all the potential complexities we've touched on, the rules, the potential for disputes, what really are the practical benefits of having a properly drafted, clear will in place, no matter how big or small you think your estate might be right now?
That's a powerful question to end on. Definitely food for thought for everyone listening. If you have more questions on this or ideas for other topics you'd like us to tackle in a future deep dive, please do reach out.
We'd love to hear from you.
Thanks so much for joining us today for this deep dive into South African succession law.